What's up, everybody? Welcome back in as we have more judge issues on this YSL case. Maybe some unexpected issues as the judge that was going to replace Judge Glanville has already recused herself, and we have a new judge that's coming to the table, and we've got a lot of thoughts on her. A lot of questions have already come in about maybe some of her connections with some of the lawyers in this case. We'll talk about that. We'll talk about whether those are going to force her to recuse herself, and whether or not any judge wants to touch this trial with a 10-foot pole. Make sure you guys hit the like button and are subscribed to our channels. Let's get into it. So I've got my dad on once again to continue to break down this case that has never-ending legal twists and turns. We've had Judge Glanville, who was forced off the case after he refused to recuse himself, was forced off the case by another judge in his district or circuit or jurisdiction. And then a different judge in his same jurisdiction was appointed to replace him. And now we have already had her recuse herself. And I found it very interesting for a number of reasons. We're going to read through her order of recusal and see why she recused herself and what we think it actually means before we ultimately get to the third judge that's being appointed to this case. So on or about June 1st, 2023, Christian Eppinger, one of the 18 defendants, was severed from the ongoing YSL RICO trial on the criminal action that was recently transferred to this court by random assignment. Although there is no severance order in the record, the court was apprised of the circumstances that directly led to Eppinger's severance. More specifically, the deputy assigned to and responsible for the courtroom and personal security of the undersigned for nearly 6 months was arrested. Said deputy, who was still assigned to this court at the time of her arrest, is accused of 1, colluding with defendant Eppinger during the current trial to commit a felony, and 2, endangering the safety of citizens within Fulton County Courthouse. What were your initial thoughts when reading that fact and those reasoning for her connection with this case?
Well, I mean, I thought that, if she wanted to, she had a reason to recuse herself.
No. I don't mean her reason for recusal. Like, that's crazy facts. Like, that's crazy that happened in this case. That is very abnormal for a deputy to be accused of colluding with a criminal defendant and getting arrested while still working for this court. That's crazy.
When I first read it, I had a suspicion, and later on in my research, it turns out. But when I first read it, I thought there's an affair going on here. There's a romantic relationship.
And that's what it is?
Yes. And the other ways it's been called an affair in a lot of the other documents or news reports, that they were having an affair.
I mean, what is going on in Fulton County? I mean, this is crazy. So you immediately went there. You immediately went affair. That's what you thought.
Yeah.
Okay.
I immediately went to a romantic relationship.
Okay. So I didn't know what the connection was. I did not look into what the connection was. I figured her mentioning it. So that's also the criminal activity. Potentially that's what she is arrested for. Some felony in regards to that.
They smuggled some things into him, did things like that. Now, and Eppinger, I don't have all the details of him, but apparently he's involved in stabbings and all sorts of things that occurred at the jail as well. So it's a bizarre group. Eppinger is apparently a very violent and dangerous guy, and he's having an affair with a deputy.
I mean, and this is literally like out of movies. I mean, what was the movie I was just watching where something like this happened, but it was a female inmate and a male guard. I can't remember what it was. And she ended up killing him and accusing him of something. But like this stuff happens in real life, similar to how it happens in movies or TV shows sometimes. And of course it's going to happen in this case, because if it can happen, it will happen in this case.
Well, that's the point. You have movies that are written about maybe one of the things that happened in this case, but you rarely have a movie that would be written about all the things that happened in this case. It'd be just too complicated.
Yeah, you wouldn't believe it. If somebody like submitted the script, they'd be like, no, there's too much in this. There's too much in this. Okay. Because this court's former assigned deputy could be called as a witness in any future proceedings in this case, the court may be called upon to assess this deputy's credibility. or rule on matters related to her criminal prosecution. This may undermine the public's confidence in the impartiality of the proceedings. So, in my opinion, I appreciate this judge recusing herself and thinking, is there a way down the road? Because a lot of lawyers think, prepare for the worst and hope for the best, right? And so she's saying, worst case scenario, if I could be called either, as a witness myself or to call on the credibility of somebody I work so closely with regarding her affair and implication in this case that I'm now the judge on, that could obviously be problematic. And just to take it a step further, if this deputy goes to trial or, has a criminal case, it could never be in front of this judge.
Well, I got to be honest with you. All I can see is this judge taking a deep breath and saying to herself, thank God I found something that can get me off this case.
Well, I wanted to wait till we got there. I don't want to jump the gun on that yet and talk about what could be coming in the future. But yeah, I mean, that's definitely one of the processes. But first, let's just focus on, legally speaking, what she's talking about in this order and her reasons for recusal and what we think about her legitimate reason for recusal, not what else we might think is going on, because we definitely share that thought, but I want to talk about it at the end. While the court does not regard the aforementioned situation as creating any actual bias for or against any party to this case, she wants to make it clear she doesn't have any actual bias. The court does view this as a matter that could cause a reasonable person to question the court's impartiality and reasonably give rise to the appearance of impropriety should the court remain on this case. So just talking about that, right? And in comparison to Glanville and how we've seen this case going and how people have made accusations that it hasn't been fair, and the prosecutors and the judge are working together or whatever it may be, it is a bit of a breath of fresh air that she doesn't even want the appearance of impropriety or a reasonable person to be able to object to her work on that case. So what do you think about that?
I think that a hard-nosed judge could have stayed on the case as long as Eppinger wasn't a party to the trial. In other words, as long as Eppinger wasn't a party, therefore the deputy would not be called as a witness. So there wouldn't be any issues involved in this particular trial, the thug trial that we're dealing with. The issues she's talking about really don't involve the thug trial and wouldn't come up in the thug trial. So yes, she has a reason. It's a legitimate reason. She has a legitimate legal reason for herself for withdrawing and recusing herself. However, another judge could have looked at this and said, look, I can stay on this trial. I just can't do a trial where Eppinger is a defendant.
And so basically that's within this judge's discretion. So she made a call, and she made the call that even, to not have an appearance of impropriety, she is not going to provide over this case. And for me, it seems like a welcome change from how Glanville was handling it, but we're going to discuss the potential problems and why sometimes you need judges to push through and do what's right and be unbiased and be fair, even if there is a connection with 6 degrees of separation. Carrie said, Peter, could you please explain what recusal means? That means the judge is removing herself from this case. She is no longer the judge because of this potential conflict, potential ethical dilemma that may be presented to her, potential appearance of impropriety for the public and loss of public confidence in her being a fair and impartial jurist on this case. So recusal just means you're getting removed from this case.
Also, interestingly to note that in when a judge self-recuses, it's not appealable.
So, which makes sense.
It does. So the fact that she recused it, that's the end of it. No one's going to appeal it. No one can question the recusal.
Rule 211 of the Georgia Code of Judicial Conduct provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. So as you can see, this is where she has the discretion, right? That, you're saying if she was harder nosed, she could have stayed on. If she really wanted to stay on, she probably could have stayed on, but she's not, and she didn't. It says might reasonably be questioned. And that's the big discretionary word there, is what's reasonable for someone for her to question her about this. She believes it is reasonable for her to be questioned. That's why she recused herself. If she wanted to go the other way, she could have said, it's not reasonable for you to question my impartiality on this trial based on what happened with Eppinger, and she could have stayed on, but she didn't. Commentary 2 to that rule provides that judges should disclose on the record or in open court information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if they believe there is no legal basis for disqualification. So she needs to put that on the record, regardless of if she was going to disqualify herself. She decided to put it on the record and disqualify herself.
If you take a look at that, interestingly enough, that really goes to the Glanville issue, right on it, because he was holding back information. And the rule specifically says that he's to disclose any information, even if he thinks there's no legal basis for the disqualification.
Yeah, which clearly he didn't. I mean, there's a million things that if you really want to look into like the rules of ethics and how we're supposed to handle ourselves that we could point to and be like, it's probably not how it should be done. Bodie said, just wanting to know what the heck, jurors wanting to know what the heck is going on. I just can't imagine being a juror in this case. I think that the 4th of July was the week they planned to take off. And so now it's been another 2 weeks since then where they're supposed to just be sitting on their hands and not paying attention or trying to figure out what's going on. That seems impossible to me, but what do I know?
Well, it is. And, if we talk about mistrials, and I don't know if you want to talk about it now or we're going to talk about it later when we talk about judge.
Well, let's wait. Let's finish the order and then we can get into mistrials.
Okay.
Thus, after careful consideration and consistent with CJC Rule 1.2a, promoting public confidence in the independence and impartiality of the judiciary, and CJC Rule 2.11a, requiring disqualification when the public might reasonably question a judge's impartiality, the undersigned hereby recuses herself from this criminal action. Okay, so again, before we get to mistrials, because let's stay in order so people can follow where we're going. So this judge recuses herself. Has a legitimate reason. It was within her discretion. She could have stayed on, clearly, as you said. She decided not to stay on, which on one hand is a breath of fresh air that she's doing the ethical thing, staying away from conflicts of interest. But on the other side, you mentioned it before. So why don't you dig in now to what you think about maybe she was looking for a way out. Maybe she didn't want to be a judge on this case. What do you think about that? And how's that going to affect us going into the future?
Well, there's no judge will look at this and say, gosh, this is the kind of case I want to take. I want to sit in trial for 10 months and have all these arguments and go through all this without a break and, not see my family like I like to see my family. Because judges, frankly, they can control their own schedules, except for really when they're in trial. When they're in trial, they have to be there every day. So you've got a situation where she might not have wanted this case. She might have thought to herself, why would I want to put myself through it? She saw an out and she took the out. Again, I don't know that for a fact, but it certainly, could be a situation where she wanted an out and she found the out.
I don't think I can blame anyone for not wanting to sit on the bench and try this case as the judge. There's so much public backlash. They're going to be watching her, under a microscope. They are going to be jumping on every potential problem. There are also people asking, do you think she should have mentioned the donation from Glanville? Or do you think she left that part out simply because one, the reason was good enough, so there was no need to list all the reasons? So I'm going to hold this question, Dad, and we're going to talk about this a little bit more when we get to the new judge and talk about who supported her and donated to her campaign. And I've had a lot of questions come in about that as well. But after reading this, my first thought was, oh, that's nice of her, conflict of interest. And then on second thought, I was like, wait a second. 18 defendants spread across multiple judges. Everyone's touched Judge Glanville in this case. Everyone's going to have some connection to a witness or a lawyer or a prosecutor or a defense lawyer or a public defender that has done something on this case. So if they all really recuse for any connection to this case, that could be very problematic. And we could end up in a situation where we can't find a judge now that can try this case. And therefore, do we have to change venue? And is that going to create an opportunity for a mistrial? And at that point, I start to think, is this really enough of a connection? Now, I think this story is crazy enough with what the bailiff is accused of doing, the fact that it was her bailiff, the fact that she obviously has some connection with that bailiff, that it was probably enough to recuse herself. That'll be different and interconnected enough that other judges won't really be able to be like, well, the bailiff in my case is the bailiff in that case. That's clearly not enough. So I do think that this was a little bit more than just your average problem that could create the necessity of a recusal, but it did make me start to worry about what's going to happen in the future. And now, whether it's this potential chance for a mistrial, Dad, or if you want to talk about the jurors now, and if they're watching this and how many come into the courtroom whenever this trial starts back up, if this trial starts back up and they're like, actually, I did see something, or I did read something, or whatever it may be, talk about how all of this delay and dealings with the judges could affect a potential mistrial.
Well, some judges may look at this and say, and I think they should, frankly, look at it and say, there's just no way we can continue the trial with these jurors. How do you explain to the jurors this gap of time? Also, they've already heard Copeland testify partially. They've already seen that Glanville was the judge when Copeland testified. So now, if during the trial, if it continues on, and you try to cross-examine Copeland based on his meetings with Judge Glanville, the jurors aren't going to know what happened to Judge Glanville. He's all of a sudden not there. This man that they respect and were told he is the neutral, they're not going to be calling him basically a non-neutral and a guy who went along with and was in cahoots with the prosecutors. How do you cross-examine and get a fair cross-examination of Copeland after all this? And how do you explain all this to the jury? There's no way to explain all this to the jury. It's impossible. I just don't think that it can continue on. I really think they got great grounds for a mistrial, and mistrials can be granted because of a manifest injustice. And the fact that a judge can say to himself, and I'm sure it would be a situation where an appellate court would certainly see that this is not your normal case. This is not the case that you see every day in the courtroom. And a judge is going to see, this just can't go on. I'm going to mistry it. It's nobody's fault. That's another thing which is kind of interesting. They're not going to blame the prosecutors for the mistrial. If anything, they're going to blame Judge Glanville for the mistrial, and therefore that it'll be a mistrial without prejudice. With prejudice would mean they couldn't try him again. Without prejudice means they can still try him again. If they do a mistrial, they'll start this case all over again.
So I think that if they did a mistrial, the defense would be filing all sorts of motions for double jeopardy, saying that ex parte hearing was really the reason, blame it on the prosecutor. I think we're going to get all those motions to dismiss if this was actually declared a mistrial at this point. And they'll blame this delay on how they handled Copeland and all of that stuff. I think there's a pretty good argument they could point the finger at the state if it comes back to the delay because of the jury, and they already started Copeland and he pled the fifth in front of this jury. I think they have a pretty good argument pointing the finger at the state as the reason for this mistrial, which then brings into double jeopardy and some potential dismissal options for them. I have heard, and I think some people told me an interview exists, I haven't seen it, with some of the lawyers on this case. And I don't want to say the wrong lawyers that were involved. I think
Weinstein, I think, said he was going to file a motion for mistrial and a motion for bond. Those are the two things I heard him say.
So, and he watches this, I believe. Somebody told me on Twitter as well. He may have been the one to say it. So, hello, Mr. Weinstein. Thank you for watching. So I also heard, though, that he and another attorney may not necessarily see this the same because they actually think they're winning the trial. And I don't know if it was him or the other attorney that said that, but they might not want a mistrial. They may not want this to necessarily go away because they think they're winning. They think this is good for them. And they think maybe the jury's picking up on all the craziness in Fulton County. What are your thoughts on that?
Well, first of all, let me say that a motion for mistrial, when denied, that's a motion that you can appeal.
Sure.
So that would be another delay in the trial, is appealing the double jeopardy motion. The other problem you've got is they might think they're winning. And if they don't file the motion for mistrial or motion for double jeopardy and they lose, then they're going to waive the issue of double jeopardy and they won't be able to appeal it if they lose the trial. So it's a real roll of the dice, a real chance you're taking with your client's life if you don't move for that double jeopardy motion, if you don't move for that.
Have you ever known a good criminal defense attorney to not file a motion for a mistrial when there's even like the slightest possibility that they're going to get a mistrial?
No. And also, I don't know a good one that won't file for double jeopardy under a situation where there is a mistrial.
Right. Yeah. So I think they're all going to file a motion for mistrial at this point, or I don't know about all of them, or if they'll join each other's or whatever it'll look like, but I think they will try. I don't know if they'll be successful, but I do think it is something that they're going to try. A couple people have written in and said, Ashley said, Peter, there's a status hearing tomorrow with the new judge. All right. So maybe we'll take a look at that. Nick said, Judge Whitaker will hold the hearing tomorrow unless the prosecution wants her out. She is our new judge. So let's take a second to take a look at Judge Whitaker. So this is another person that a lot of people have been tagging me in a lot of their tweets and seems to have very legit information. I don't know them, so I can't like personally vouch for them or anything, but everything I've read has been just kind of straight up saying what's going on, this Thugger Daily account. And he posted, this is the new judge. Okay. What's really interesting about this judge is um so first off, he said the judge or this source he trusts, what's Judge Whitaker's reputation? That's who Woody just pled his last case with. So that's interesting. She has that connection to the case. Former head of the appeals with the DA's office, fair, maybe lowest case count in the courthouse, efficient. So if these two things are true, how does that affect the way we look at this judge as far as her ability to handle this trial?
Well, just a little background. Before she was head of appeals, the DA's office, she was in the appellate section of the Attorney General's office of Georgia. She graduated from Duke. So you're talking about someone here who is very smart on the law. Remember how we kind of complained that Judge Glanville was not real good on the law and made a lot of mistakes when he was doing the contempt on Steele, a lot of legal issues that he was having a problem with. Well, she's not going to have those mistakes. An appellate lawyer knows the law, so she's going to be very good on the law, and she's smart. So I think that she's going to be real good, and she's going to make sure she does things right. And it's going to be tough on this case because, frankly, there's almost no precedence for this type of case. I can't hear you, Peter.
Yeah, I know. I was talking to John.
Oh.
So again, the question that I asked was, that's who Woody pled to on this case. So how do you think that affects her ability to handle this case? And then we'll get to the second text. But I want to know specifically about these two texts, how you think this affects her ability to handle this case as the judge.
It's not going to have any impact on her. It happens all the time where they take a plea and the witness they take a plea with, that person becomes a witness. In fact, that's a regular case because, for instance, just give you an example, any multi-defendant case, you're going to have people that are going to flip in the case. And one judge is assigned to the whole case number. 3 defendants flip, they get a deal from the prosecutor's office to testify against the other defendants. It's the same trial. It happens during the middle of the trial. A defendant will flip during the 3rd day of the trial and become a witness on the 4th day of the trial. Well, it's the same judge. So there's no issue and there's no conflict. Happens all the time.
Right. And judges are judges in front of lots of defendants over all these years, taking pleas from all sorts of defendants. It doesn't mean that any defendant that has ever been in front of a judge or taken a plea in front of the judge or been convicted in front of the judge can't become a witness in a totally different case, or in this case, it just doesn't matter. That's not a reason for recusal. And then the second part, which you kind of already mentioned, her appellate experience will be really good for a case like this and really good for the issues that we're already faced with. And the fact that she has the lowest case count in the courthouse and that she's efficient sounds great for like the least efficient and longest case of all time, right? That seems like a pretty good combination. One of the questions I had for you as well, based on this and with her appellate experience, knowing that she is going to be faced potentially with motions for mistrial, she's the one that's going to answer those questions. So what the heck does she have to do to prepare to be able to appropriately analyze and answer these questions?
Well, first of all, we know, she knows the pitfalls in granting a motion for mistrial. She knows you can't put it on the prosecutors, because if you put it on the prosecutors, it becomes double jeopardy and it becomes with prejudice. So they can't be retried. So she's going to stay away from putting it on the prosecutors. She is great on the law. Those mistrials are really almost totally based on law. They're going to have to show some case law that requires it. Mistrials are rarely granted. I think you mentioned a while ago, there's probably been 100 motions for mistrial in this case already. That's the way it is in every case. You file a motion for mistrial, you preserve your issue for appeal, but it's the odds in it being granted are slim and none, except the motion for mistrial for this case to start over again. I think the odds are real good on that one.
So another thing that he posted here is join criminal defense leaders to reelect Judge Paige Reese Whitaker. Okay, so this is something that has come out that people are asking about. And then we look at this list and we see Brian Steele, I thought there was another lawyer on here. Isn't Ed Garland your buddy? Is that who you were saying
Ed
you knew?
Garland's my buddy. Yeah,
Yeah. Okay. So you said you had a couple buddies on this list.
I
So
do.
so we have this flyer here. Okay. We've already talked about Glanville supporting one of the other judges. We don't know if Glanville did or didn't support this judge. I haven't seen anything like that yet. But when talking about reasons to recuse, or will the state try to recuse her or disqualify her, I should say, talk about how important or not important something like this would be, where criminal defense attorneys are supporting judges that end up in front of practicing in front of them.
Well, first off, it's a good thing that criminal defense lawyers are actually supporting a judge. Here we have someone that's a chief of the appellate division in the prosecutor's office. Yet, defense lawyers think that she's fair enough that she would make a good judge. So it's a good thing for people to look and say, well, here's a prosecutor that defense lawyers think are fair. This is going to be a balanced person. That's the kind of person we want to sit on the bench. In fact, if you go down here, Peter, see Don Samuel down there?
Yeah.
We have his book in our library. He wrote the book on the 11th Circuit case law. So Don's on there. I can tell you those two that I personally know are tremendous lawyers. They're not going to endorse somebody that they think is a total jerk, but someone they think is fair. She must really have a reputation for fairness for these lawyers to be endorsing her. And so I think it's a good thing when people look for who they're going to vote for, any citizen. I think you should look for someone who's balanced, who has both the prosecutorial support and defense support, because then you know that that person's a balanced person. She was a good one. And by the way, she also was put up, she was on the short list for the Georgia Supreme Court not too long ago. She wasn't picked, but she was on the short list to move up to the Supreme Court.
Yeah. And that's what I'm saying. I think this is, we can go off on a tangent kind of, but like, this is what you're looking for. Somebody the defense attorneys like, someone the prosecutors like, somebody who was a prosecutor, but they felt she was fair enough, or maybe because she did appeals, whatever it may be, that everybody likes her. And that's all great and good. This is never going to be a reason that a judge has to recuse herself in a criminal trial in a case, ever. Never. Or defense attorneys wouldn't support judges. Sometimes they donate. Obviously, if they give a judge $1 million maybe, but the $2,000 or $500 or whatever it may be that they donate to a campaign is never going to be the issue. And I will just say, we have supported a lot of judges in the past. Sometimes it's worked out well. Sometimes it hasn't. Sometimes we like doing it. Sometimes we don't. Sometimes it can get messy. And a judge is like, you supported this person and not that person. You supported the winner. You supported the loser. So there are issues with it when the lawyers get involved and do support judges, but it happens all the time. And there's actually a situation here in our jurisdiction where one of my buddies from law school tried to recuse a judge because a defense attorney supported that judge and lost. And it was a bad argument and it didn't go well. And I'll just kind of leave it at that because I really do like that guy that filed the motion that lost, but it is almost never a reason on its own to get booted from a case or not be able to try a case in front of a judge again, just because you supported them for judge or supported their campaign.
Well, it's only logical. I mean, who is going to fund or contribute to a judge's campaign other than lawyers? I mean, you think about it, they know the people the best. They know what the job entails. And so they're the logical people to do these contributions. Throughout the country, I don't know any jurisdiction that restricts lawyers from contributing or supporting to judges' elections.
And Thugger Daily said, if she wants a way to recuse herself off the case, she has multiple. I think, and this would be one of the situations where I actually think if she recused herself, it would seem even more fishy than the last judge, because these would seem like a reach, because some other witness took a plea deal in front of her, or because the defense attorneys supported her. I think she would have to have some other connection or something more than this to have an actual appropriate recusal of herself. Don't you think? Don't you think it would look like she was reaching for a reason not to have this case?
Oh, absolutely. And it would look kind of funny that one judge gets recused for cause, second one resigns because they find a way to resign, and then you got another judge who, I agree with you. I think that she's got to stay unless they can find something really concrete to kick her off.
I agree. And I think that also you said she was on the short list for the Georgia Supreme Court, which I didn't know, but as hard as this case is, as miserable as this case is, If you come in and you do a really good job, and right now the bar is not set very high, maybe that would propel you to be not just on the short list, but someone who becomes a Supreme Court justice in Georgia, right? This could be a career advancement for her if she handles it appropriately, shows how fair she is to both sides, and moves the case forward appropriately, don't you think?
Oh, absolutely. And she wants it because she applied for it once. So she wants to move up. So I think you're right. And let's face it, it's a smelly case. It's a high profile case that's a mess. If she comes in, cleans it all up, and ends up with a fair trial that gets upheld on appeal, she is going to look great. Her profile is going to be high, and she'll be a logical choice.
Yeah, and that's what I'm saying. And there's nothing wrong with that, right? I mean, people are going to
No.
say, "Oh, it's so bad," but it's like, no, this case sucks. This case sucks to be the judge of this case. And you know where it sucks even worse? Now, to come in and clean up the mess. It would have been one thing if you were the first judge on it and you could have done it your way, but to come in now is infinitely harder to get this thing back on track. And if she's able to do it, kudos to her. Sandy asked, if they declare a mistrial, would it be better to split up the defendants? Could that shorten the trial? So what are your thoughts on that? I have some thoughts on that, but what are your thoughts on that?
Well, it wouldn't shorten the trial because if you split the defendants up, that means you have two trials. You have to pick two juries, and you have to present the witnesses twice. So it's not going to shorten things up in the long run. It would not be judicially cost efficient to do that. It is very difficult to try multi-defendant cases. I've prosecuted them and I've defended them, and it's really hard. It's very hard for the judge. But it is cost efficient to try them all together. So I don't think they're going to split them up.
In your opinion, who usually pushes more to sever cases?
The defense.
Yeah. So that's what I was going to say. Like, as far as the prosecutor goes, usually they just want to go. And the reason that they'll argue is exactly the opposite here, Sandy. I get what you're saying. And based on this case, I get why you feel that way. But most of the time, prosecutors say it's infinitely faster to try them all together because we got to call all the same witnesses now 6 different times. We got to get Woody on the stand 6 different times. We got to get this person there. We got to get this cop on the stand. And we can't testify to this in this trial because it touches that guy, whatever it may be. So the prosecutors usually push and say it's infinitely easier to do all this together. Doesn't seem or feel that way here. But the defense attorneys usually want to sever, which is also interesting because now it almost seems like the defense attorneys are a team. And even though they represent their individual defendants, when something like this happens where the judge screws everybody or the prosecutor screws everybody, they get on the same team and fight them together.
And again, she is the kind of, I really believe they picked a good one here. It was the wheel and it was a random choice, but she's also got a lot of good experience. And she's also, Peter, you and I know this and your listeners, but she's a member of 2 ends of court up in Atlanta. So she is a person that mixes well with the private lawyers. She goes out socially. They have dinner together. So, they know her, she knows them. So it'll be a congenial atmosphere in the courtroom. That makes for congeniality. That's what ends of court do. That's the idea of it's kind of a club that professes that. She was also on the board of governors for the State Bar of Georgia. So she is very active in the bar and very active. So she's a well-known person, well-known face, and she's out there socially and gets along with people. And that kind of person tends to give you a fair trial because you really, if they're a nice person and you get along with them and you know them and you have dinner with them at meetings, it's not the kind of person you yell and scream at and make accusations that you really can't prove.
Right. And I mean, when you talk about, you have to be careful when you talk about having dinner with defense attorneys and mixing it up with them. These are like that bit. These are like, there's 50 people there and you split off into 10 groups of 5 and each group does a presentation and you pick a part of a trial or whatever it may be. And everybody works together and there's usually one judge in each group. So we get to know the judges present to, they're just one of us common folk in these, ends of court meetings. And it's really cool. And it's a really good way to get to know judges. It's a really good way for young lawyers to get to know judges and have the opportunity to learn from them. And not every judge does it. So the fact that she's in 2, I agree with you, really shows well for her. Traveling Teresa said, can we address the prosecution misconduct? Do they just get off scot-free? So even if she does not grant a mistrial, or if she does grant a mistrial and doesn't blame it on the prosecution, there are still arguments the defense can make against the prosecution.
Right. They still can make it, but I don't know if they're going to be successful after that order that was written saying that there was nothing wrong with the meeting. So I don't know now. I believe, and I'm not sure we know who, but hasn't somebody filed a bar grievance against Love?
I have no idea.
I thought
Unless somebody sent
I
it to
heard
me, I
that,
haven't seen it.
but I know that people have denied it. Who they said, have you filed it? No, I'm not the one that filed it. But there's still the possibility that there could be bar discipline for the actions that the prosecutors took.
Yeah, and we'll see. Bodie said, does it matter if the defense likes her? So, and that's also kind of a misconception, I think, too. It's a good question, Bodie. I appreciate you asking. But us liking a judge. I have lost, and you have lost plenty of cases in front of judges that we're friends with, or friendly with, or like, or respect. Just because we like a judge, or respect a judge, or think a judge is fair, doesn't mean they go in and just do whatever we ask. It doesn't mean we win every case in front of that judge. It just means we're going to get a fair shake. And that's really all we care about as criminal defense attorneys. We lose more than we win as criminal defense attorneys. That's just kind of how it is, because the prosecutors have all the resources, all the money, all the time, all the power. They choose which cases they want to take. They choose which ones they don't. And that's just kind of how it is. So, does it matter if the defense likes her? Yes, because that usually would mean she's fair.
Yeah, well, and that's the point. That's all. You're right. All you can ask for is a fair trial. That really is all you can ask for. And one of the things, you mentioned it just now on your list, the prosecutors pick the cases they try. Remember, if it's a bad case and they think they're going to lose, they don't charge it. So you only are going to go to trial on cases they already have decided they think they can win. Otherwise, they wouldn't have charged the case.
Nick said, Attorney Harvey asked to sever the case for his client since pretrial. Mr. Nichols is only mentioned twice in the entire indictment. Yeah, and that's the other problem, is you just have these windfall verdicts where it's like, we're just going to convict everybody because we think, Young Thug or just one person did something or was really the king of this, and everybody's guilty by association. That's a major problem in these multi-defendant trials as well.
Right, but I've got to be honest with you, jurors surprise me sometimes. They surprise me a lot, in that you will find in these large trials, they'll find 20 people guilty and then 1 or 2 people not guilty. So jurors really take their job seriously in most cases, I think. And they will go through each individual defendant and the evidence against that defendant. And like I said, I've been surprised at how good they do.
Yeah, and I don't mean to say that they're not fair. I mean to say that once you start thinking the criminal activity is being done by the criminals in the courtroom, sometimes it's hard to separate and just pull one out. Not to say it can't happen.
Right. There's
it's
a
harder than if
spillover.
that person was being tried individually, I think.
Yeah, there's a spillover effect.
Unknown Me said, since Whitaker is the judge, how long do you think it will take for court to resume? Well, we hear there's a hearing tomorrow, but after that, for actual trial to resume, I have no idea. What's your thought?
Well, resume is a really broad term. I don't know what resume really means in this case, because I don't know if she is going to start in the middle of the trial, which again, there's no precedent. I couldn't find a case in Georgia where this kind of thing happened in the middle of a long trial like this. The theory is you can read the transcript to catch up, but who's going to read 6 months worth of transcript? There's got to be a good 10,000 pages. My guess is resume is going to mean she's going to hear the motions for mistrial. She's going to rule on them. Again, I'm going to make a prediction. She's going to grant them without prejudice so that the case can be tried again, and they're going to start from the beginning.
Yeah, I have no idea. I have no idea when it's going to resume. I hope sooner rather than later, but I hope she doesn't rush it. I hope she does, do her due diligence and doing all the background on the case so she knows what's going on, knows what the priorities are. I'm sure she will. Azam said, I missed wishing you yesterday. Happy belated birthday, Papa Tragos. Happy anniversary to you and Whit. Peter, thanks for spending time with us. Thank you, Azam, for
I want to thank everybody too. They had a lot of birthday wishes. So thanks a lot.
That's right. Probably more than you've ever had in your life. What about Bond? Do you think any of them are going to get Bond?
I think there is a chance we're going to get some bonds out of this.
That would be
I do.
Wild.
What?
That would be wild, don't you think?
I think there's a chance. If she grants the motion for mistrial, first of all, she's going to have to find a new trial date. That new trial date is going to be pretty far in advance because you're going to have to find, 10 months worth of trial date. She might decide that it would be unfair to keep these people in prison all this time, or in jail. Actually, it's not prison. They keep them in the county jail all this time.
You might be giving her a little too much. I would be shocked if there were bonds.
There
I've been
might
wrong
be.
before, right? I've been wrong before, and you've handled a million more criminal cases than I have. But with these charges, with witnesses saying they're in fear for their life, with connections to the outside world and gang activity, which they've been accused of, I would be really surprised if they were handing out bonds, unless there's somebody that's like very minutely involved that's still sitting in jail right now that I don't know about.
What about the guy you just talked about? He's mentioned like twice in the indictment, minor
I don't know.
player.
I don't know specifically what they're talking
I mean,
about.
I know, but I think there's some chance of that. They've got good arguments for a bond.
What typically happens after a status hearing? I mean, this is not a typical status hearing,
No.
but the case usually moves forward and they decide what's going to happen next, maybe some scheduling, what's the status of what's going on. I mean, there's just a million things going on in this case, so it's not going to be like your average status hearing. Do you think Ashley Merchant can step in regarding the prosecutorial misconduct? Mixed chick Samantha asked. I don't know how she would step in on the prosecutorial misconduct. It would be the lawyers who are representing the defendants in this case. She represented Brian Steele. I don't think that would come into play here in this trial as far as getting it dismissed unless they hire her on. One of these defendants hires her to be one of their lawyers. Additionally, I don't see how she would affect that. All right, let me see if there is anything else. All right, so we're going to call it here because at 3:30 in about 2 minutes, if you have the auto play button, it's like a play button that you can click on your video. It'll automatically redirect you to the next live. I'm going to be breaking down what's going on in Karen Reed, and it's not good news. It's not good news in the Karen Reed trial for either side. So we're going to go through that. I'm going to hit Nick's question here as the last one. Peter, no witness has ever testified that they are afraid for their lives. The prosecution tries to claim it, but no statement from any witness. Okay. So maybe it doesn't exist and it's just being reported out there, just being said by the prosecutors. I know I've seen it said on the stream, but it may have just been said from the prosecutors. Again, we'll see. And that'll be a part of the requirements that the judge is going to have to determine and use in balancing whether or not to give bonds. So we'll see. But Dad, thanks for joining me. Everybody else, hit the like button on this one. And then when you get to the next one, until next time, and maybe tomorrow, if we can catch that hearing, maybe we will do another video on this stuff. If you guys want it, let me know in the comments. Cover the hearing if you want us to cover the hearing. But for now, that's all we got. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.